Now, the ruling came out earlier today, the decision came out earlier today, and ultimately it sets a precedence that could be perceived as dangerous. What do you make of all of this?
Sure. Well, look, this is a very serious issue, and all I really hear from the left is the idea that there is no explicit constitutional immunity for presidents, especially after they leave office. And look, there are lots of immunities that are just creatures of case law, that are creatures of judge-made decisions. So, in my role at the Justice Department in multiple litigating divisions, going back to 2001 when I first joined the Justice Department in the Bush 43 administration and also in the Trump administration, it was very common for me in terms of lawsuits that were brought against the government to assert something called sovereign immunity as a defense, which is basically an argument that the government can't be sued unless it gives its consent to be sued. And that is not something that exists in the Constitution. It is something that has been created because it goes back to ancient common law that the king was essentially, not to be sued unless he agreed in some capacity to be sued. And we've continued that tradition. And while there are waivers of sovereign immunity, and also states have sovereign immunity too, and they can waive their sovereign immunity in under the 11th Amendment. It's a situation of that immunity has been recognized, even though it doesn't explicitly exist in the Constitution. So the president's lawyers have argued that the same here for the president. The president has to have immunity for his official acts while he is in office, as long as he is colorably acting within the span of his authority, or what the Supreme Court has called on the civil side, because there is clear case law created immunity for the president in civil cases as long as he acts within the outer perimeter of his function. And so the argument would go here that anything that the president did to look at investigating the 2020 election, arguing that it was illegitimate, arguing that it was flawed, arguing that it was marked by irregularities, all of that is within the span of his office because he is the chief magistrate of the United States. So in this DC Circuit decision today, which comes from two Biden appointed judges and one Bush 41 appointed judge, Judge Henderson, they have rejected that. And they have essentially tried to set it up for a rocket appearance right up to the Supreme Court. And let me pause there, Breanna, and see if you have questions before I describe how they've tried to game the system to get this case up to the Supreme Court as soon as possible.
Well, actually, that was going to be my follow-up question because, like we've been telling our audience, that's what they're trying to do. The ultimate goal here is to interfere in the upcoming election. So I'll let you take it away and continue to your next point.
Sure. So, look, my colorful way of describing this point is, over the weekend or just before the weekend, Andrew Weissman was on MSNBC along with Neil Katyal, who was saying that they're both freaking out about the fact that they didn't have this DC Circuit case yet. I think it took about 55 days to today to get it. Obviously, they didn't know it was going to come out in just a few days. Either that, or they reacted to what Andrew Weissman tweeted, which he reemphasized in his MSNBC appearance. Snap a doodle. The DC Circuit needs to wake up and get this case done fast and deny Trump immunity. Well, obviously, we know that the left wants to deny Trump immunity because they want him to be subjected to a criminal trial before the election. But the snap-a-doodle point is the point that really makes me sit up and take notice, which is the idea that this must absolutely positively be decided so that President Trump can be tried before the 2020 presidential election in November. And there's really no basis for that. A case like this, with the stakes that we're talking about in terms of whether there is presidential immunity on the criminal side, it's a question of first impression for the Supreme Court. It's a question of first impression for the DC Circuit that just decided today. It would not be unusual at all for a decision like that to take months and months, and maybe even as much as a year. So what that is not compatible with is not ordinary judicial timetables. What it's not compatible with is the political timetable of the Democrats, who want to try to knock Donald Trump out of the running because they're afraid that if he's the candidate, he'll return to the White House starting on January 20th, 2025.
Yeah, yeah, I think that's what they do fear. And ultimately, listen, if they're saying that he doesn't have precedence, like if he doesn't have any immunity with this ruling and this decision, that ultimately, when he does get back into the White House, he could possibly do the same thing to Joe Biden and potentially Barack Obama. I know he said that if he were to get reelected, that he wouldn't do this. He's got too many issues that he needs to fix. But ultimately, could this decision be applied to going after President Joe Biden then?
Sure. And look, let me put a footnote in how they're really trying to speed this up because it's a little bit technical. But let me answer
Yeah.
your current question, which is, look, this is something that the judges on the left are starting to realize that, what's good for the goose is good for the gander. So let me use an example of what happened with Mark Meadows' removal case in the 11th Circuit, right? That's, the circuit that covers Georgia. So he removed his case down there as one of the defendants in the Fonnie Willis prosecution, which, in full disclosure, I'm one of the defendants of as well. And I've also removed that case. My appeal is in an earlier stage than Meadows. And, Meadows removed that case. He lost at the district court stage and he lost at the 11th Circuit panel stage, 3 judges. And they ruled for the first time, as they acknowledged in, more than a century and a half, almost 2 centuries, that the statute allowing federal officers to remove does not apply to former federal officers. It only applies to current federal officers. And that prompted 2 of the judges, the Democrat appointed judges, to basically recognize that this was something of an emergency. They voted, I think, because it skewered Trump and skewering Meadows, I think they see as somewhat equivalent, or by transitive property, like screwing, Meadows helps them do that, he could not remove. But they realized that, look, that could mean if the Biden administration ends, that all of the Biden administration officials suddenly would not have the power to get out of red state or red city prosecutions that are brought against them for things they did while they were in the Biden administration. So they were saying Congress might want to look at fixing this. Now, I don't think the law really needs to be fixed. I think the decision's in error, and that's what Mark Meadows is arguing. That's what I've argued. But that's an example of the fact that they see that this could have a boomerang effect. And the immunity point, as you just made, is the same thing. If they can't just say that Trump lacks immunity, right? If Trump lacks immunity, if the president lacks immunity, then any president lacks immunity. If any statutes of limitations were still live, you could go back to to Obama and re-examine his actions, and he would potentially not be immune for things he did while he was in office if criminal actions or other kinds of suits were brought against him.
Yeah, we have a tweet on the screen right now. It's a part of the section of the decision today, which ultimately cites Bill Clinton and the Paula Jones ruling. But that was a civil lawsuit, and the interesting part in that was before those were allegations before he became president. So they're citing that, but that was before he became president. So ultimately, this just seems to be reckless at this point. I don't understand why they would cite that. But I do have a question for you, Jeff.
Sure.
Ultimately, if the Supreme Court rejects taking up this immunity challenge, where does the president go next? Because they don't have to take it up, is my understanding, correct?
That's right. This comes up in a posture called a petition for a writ of certiorari, which is another ancient common law term. So it means it's part of the Supreme Court's discretionary docket, which is the vast majority of its docket. So in order for the Supreme Court to take the case, 4 out of the 9 justices have to agree to take it, but they're under no obligation to do so. So, and you don't, unless there are dissents from denying cert, you rarely get a count, right? So you usually just get an order that says cert denied, and you don't know what the internal vote was. Did it fail by 1? Did it fail? Did they get no votes? So it is possible that they don't grant cert, but I think that they will grant cert in this case. It's too important,
Yeah.
and it's too novel. And they realize that it has earth-shattering implications. If the president gets tried before the election, that could be enough election interference to change the outcome of the election just standing by itself. And I don't think they're going to let this go forward, with a precedent from the D.C. Circuit, because that's, people often think of it as that's like the court just below the Supreme Court. It's sort of, all the circuits are equal at some level, and there are 13 of them, 1 through 11, and then the DC Circuit, and then an unusual circuit called the Federal Circuit that deals with things like patent law. But the DC Circuit stands a bit above them because of the nature of the cases it takes and its jurisdiction, and the fact that a lot of its judges get promoted to go on to the Supreme Court. So I think this is too important a precedent, too groundbreaking an issue. I think they are going to take it. The question will just be when. And I also think, in terms of the lawfare strategy, Breanna, that the left is trying to overload the Supreme Court with cases. They have the Colorado case and other potential cases trying to keep Trump off the ballot. They have this fight about a criminal statute about obstructing an official proceeding, which fully comprises half of the Jack Smith indictment in D.C. against President Trump. If they took this one, they'd have this one. I think what they're trying to do is hope that one of those 3 Hail Mary passes, I think, for them at this point, succeeds. And they hope to sort of use up the Supreme Court's capital. I also think, looking down the field at a fight about whether the 2024 election is above board, right? If it becomes necessary for President Trump to challenge that election in the courts, they want the Supreme Court to be so wearied, so tired of Trump-related cases where they have to come in and set the lower court straight, that they just throw up their hands and say, you're on your own, and they deny cert, just like back in 2020. In December of 2020, they denied review of the Texas case joined by like 17 other states that Ken Paxton filed to try to get review of the irregularities in the 2020 election.
It's interesting that you say that, because I actually didn't think of that strategy, but it makes sense. Ultimately, yeah, you want to overwhelm the Supreme Court so that they don't take on other cases that are extremely important, like the one you just cited, potentially. It's so heartbreaking when you think about it, because this form of lawfare is only being practiced on one side. It's not being practiced by
Yes.
Republicans. Democrats have mastered it completely. What can Republicans do to push back? Because I think that's really critical here.
Well, here I think we can support the president, and I'm self-interested in this, but we can support other targets that the left has lined up. People like John Eastman, people like Rudy Giuliani, people like the alternate electors in Georgia, and people like attorneys who represented President Trump or represented others who are trying to get to the bottom of the 2020 election. That this 65 Project and other groups like Crew have launched litigation against, and there's another group in Boston called LDAD, Lawyers Defending Something or Other. And they're trying to get lawyers who are conservative and who want to see election integrity disbarred. So we have to fight against that. I'd urge your viewers to make contributions to help support that fight. But if President Trump does return to the White House, and it's not something that's prevented from the current Congress taking it up, I just would suggest that probably the Democrat Senate in Chuck Schumer would block it. I think we need new laws. I think we need a new venue law that moves venue out of D.C. to potentially even a new court in the center of the country in 2 major areas. One is, if you come to D.C. to protest in a publicly permitted First Amendment protected protest, and it turns out that you are accused of some crime or some other infraction, that you should be tried back in your home district, the district that you came from DC to DC, as a temporary visitor, where your real peers are, not in DC, which is, more than 90% Democrat and not very sympathetic to conservatives who want to protest. They are only sympathetic, it seems, to Antifa and Black Lives Matter and causes like that. And those people, for that reason, get off scot-free even when they engage in far worse behavior. And the other category of folks who should have the ability to change venue, and this is where potentially a newly created court could come in, is any officials who go to serve you would have to make it neutral, obviously, in any administration, would have a venue option to be tried either, in their home state or to, stay in DC if conduct that they engaged in while they were in office was brought into question. Both of these things would help avoid massive bias against the conservative side and just make things a lot fairer. And here's an example of using current law. I just happened to read today a motion that David Schaefer, one of the alternate electors down in Georgia that Fani Willis is pursuing, he filed a motion to change venue, and he wants it changed out of very deeply blue Fulton County, where it is currently, to basically a 50-50 county in Georgia, on the theory that would better guarantee that you would get a fair trial. It makes a lot of sense. So that mechanism also currently exists to move venue in DC, but none of the DC judges have granted it, even though I think the bias against the January 6th defendants is extreme. And so that's why I suggest that I think if there is a new administration with a new Congress with Republican control of the Senate, I think we need new legislation, Breanna, to establish that.
Yeah, and the Constitution says that they have a right to an impartial jury, and these judges are gripping onto these cases, like you said, and not letting them leave the venues that they're in right now because they know why. It's heartbreaking to me because I've seen so many J6ers as they try to make those arguments in front of a judge think that at the beginning stages think that the courts would rule in their favor since it's common sense that they can't get a fair jury in Washington D.C. And then it's like a slap in the face when the judge rules against them because it's the Constitution. You would think that they would abide by it, but unfortunately, it just doesn't seem to take place like that right now. Before you go, Jeff, I wanted to get your take on what's happening with the Supreme Court this week. They're about to take up the 14th Amendment case in both Colorado and Maine. Those are both of the states that are trying to boot him off of the ticket, as many of us know. What do you make of this? What do you expect from this ruling? Do you think that they're going to uphold getting President Trump removed from the ballot?
I don't think that's going to work. I think even the left recognizes that that's even less than a Hail Mary pass for them. But they like the fact that it just keeps in the news this mainstream media narrative of Trump engaged in an insurrection, Trump engaged in an insurrection. And I don't see this point made frequently enough, but it's a really key point. How did the Colorado Supreme Court and then the trial court before it that the Colorado Supreme Court affirmed, how did it find that Trump engaged in an insurrection, right? There was no real trial. What they did was they took the January 6th committee report. They said that January 6th committee report was reliable, and then they adopted the facts. And then in order to provide some patina, some veneer of fairness, they brought in the chief investigative counsel that Nancy Pelosi and Benny Thompson had handpicked, this guy, Tim Heaphy, a former U.S. attorney. And, he was asked, like, was this a fair process? Did you guys have an open mind? And of course, he says yes. And that was enough for the Colorado trial judge and the majority on the Colorado Supreme Court to say that's good enough for us, good enough for government work. Ergo, President Trump engaged in insurrection. It all traces back to this very corrupt, politicized, monolithic January 6th committee, which, as you'll remember, then majority leader. I'm sorry, minority leader in the House, McCarthy, refused to send members to because Nancy Pelosi wouldn't seat Jim Jordan, and others on the committee. So it was a totally stacked committee. And Heafy can't really bless that. That was allowed. But, anyone with a modicum of common sense and fairness would say that was not a fair process. President Trump couldn't cross-examine the witnesses. I couldn't cross-examine the witnesses. John Eastman couldn't cross-examine the witnesses. Yet, it's supposed to have produced this ruling that President Trump engaged in an insurrection. It's a real farce. It would be the easiest, at some level and most logical for the Supreme Court to say there was no insurrection. I think they may try to stay away from that because that kind of gets their hands dirty with the facts. I suspect it's more likely that they say that President Trump isn't even covered by the 14th Amendment, which is a topic and the main defense I've written about, or that it's not self-executing, or that President Trump was already acquitted of insurrection and acquitted of a Section 3 of the 14th Amendment violation because the second impeachment against him, that was the sole article of it, and it failed.
Now, as you just heard, Jeff Clark is one of the many Fulton County co-defendants facing the persecution of Fulton County District Attorney Fani Willis. He's also being persecuted by the D.C. bar as well. He's not only just a good a friend, but a great American, and he is taking on a lot right now. This is a man who stuck his neck out for this country and offered to simply investigate claims of election fraud. And I told you guys before, there were other FBI agents who I've spoken with directly who wanted to investigate these claims as well. They were getting tips, but they were shut down. And one of them that I spoke to was actually forced out of the FBI. So ultimately, this is a big machine, and it is coming after Jeff Clark, and he's a great American, and he could use all of your support. So if you head over right now to his Gifts and Go page, it's the Jeff Clark Legal Defense. He'd really appreciate anything that you could throw his way, guys. He'd really appreciate it because they're trying to destroy this man. And as you just heard from him, he is a great patriot, a great American, and he deserves all hands on deck with this massive legal battle he is taking on. I can't seem to shut up about how amazing the quality of my sleep has gotten since I switched over to MyPillow products. Yes, I know you've probably heard of it before, but these new products that just came out, the 2.0 line, are incredible.
MyPillow 2.0!
I'm sleeping on MyPillow Giza bed sheets. I'm also using the new MyPillow. And let me tell you something, guys, I am sleeping like a baby. The bed sheets are incredible. It's literally so soft and yet so thick that you feel like you're sleeping at a 5-star resort.
Excuse me, where's the lobby?
Down the hall and to the left.
Thanks.
Now, if you're interested in getting a better night's sleep, you gotta head over to mypillow.com. Use promo code Breanna, that's BREANNA. If you're looking to save up to 66% off, you gotta go now before they sell out, guys.